everybody. Welcome to another edition of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, back with my co-host, Julio Vela. What's going on? We had a little unexpected break last week.
Little bit, a couple days off. It led to cabin fever, led to my kids going crazy, led to, and this. But
some ice, some snow. We've had it all this year.
we have. Anytime I'm sitting next to, though, a fellow South Texan, Lori Botella, running Republican judge, as a Republican Ford judge.
Yes.
I'm pumped. Lori, how you doing?
I'm good. Thanks for having me, guys.
No, it's good to have you on the show. You're out of our series of candidates that we're going to be having here. You're the first Republican to appear on the show. We've extended invitations to a bunch of other candidates on both sides. As we told you 2 weeks ago, sorry we encountered a little bit of a issue last week. We couldn't get on the air last week, but that's okay. We're on this week. And so Lori's here to join us. And, we'll be here the next hour talking with her about her campaign. We'll talk about some current event issues going on at the courthouse. You can hit us up. I have Twitter on. You can hit us up at HCCLA_TV or call on the phone, 713-807-1794 is the number. So, Lori, what made you want to do this? And I say that, and I know that's such a trite question. Everybody asks that, but look, judges are politicians essentially. I mean, you're running as a politician, you get criticized, and I get along with some judges. I may not see eye to eye with some others, and we all have different relationships with judges. At the end of the day, though, I view the judges as kind of the quarterback of an NFL team. You get all the blame when it goes wrong, and not enough of the glory when you start doing things right. I mean, maybe more like a head coach, because I guess the quarterback does get a lot of the credit, but maybe more like a head coach. You really don't get enough credit when things go right, but man, you get an earful when things are done wrong or when people don't like it. And it's just like any other politician. I mean, we're seeing it now that there's this kind of backlash of things. So what makes you want to get into this whole realm of politics?
Well, I first thought about running in 2013 for the 2014 election cycle. And I just hear so many complaints from lawyers about, judges' policies, how they act on the bench, the timeliness at which they arrive to court. And I was practicing in Montgomery County, Fort Bend County, federal court. And so I got to see how different judges ran their courts. And I got to practice in front of lots of different judges. And I thought, I have some ideas to run a good court, to be a place where lawyers enjoy coming to practice, to be a place where we could do some things more efficiently instead of the waiting around and waiting around. So
Hurry up and wait.
But I did get pregnant the fall of 2013, and so that put off that decision. And so when this cycle came up, a bunch of judges were considering retirement, and I just seized the moment as soon as I first filed when Larry Stanley decided to retire. I first filed for Court 6, and I decided I'm going to do this. So let's go. Let me do it.
Allow me to say.
You're the co-host.
Well, I love Judge Bull. Okay, Judge Bull has been on the bench for a number of years. She's always had a fair trial. She's always given me a fair shake. And you're running for County Criminal Court at Law number 11.
Yes.
So, let me ask you this: is there a new Republican movement, or is it going to be the same policies that are coming in, or what new things do you bring to the table, or is it going to be more of the same, which quite frankly, Judge Bull runs a good court?
She does. I agree with you. I think she runs a great court, and I have a lot of respect for her. There's been so many changes, though. Hurricane Harvey, we're displaced, so we've had to share courtrooms. We've had to change how we do jury trials. We've got these jail dockets. I mean, we're covering a lot of ground as lawyers. And I went to a meeting this morning, and I heard Ed Emmett say that the plan is to rebuild the criminal justice system from the inside. So not tear down the building, but redo it interior. Who knows where the courts are going to be? Who knows where the DA's office is going to be, or public defenders, as far as like location, which floors. But I think now's the time, with all this change going on, to streamline some of the policies. We've got e-filing that just started. We're navigating that kind of rocky road right now. But I think with
A lot of rants about that too.
there are a lot of rants about e-filing. And it's just like everything, when something new happens, you've got to adjust. And I'm sure...
And people say they want change, but then when they get change, they don't like it. This is you know, kind of the conundrum that people are in. That, you know, and unfortunately, I go back to my initial question, because as a politician, you have to be the one to implement changes.
Yes.
And a lot of people are not going to like that change. They may come back and say, "Well, I can't believe she did that." You know,
Sure.
I mean, you're going to have people that have been your colleagues that'll say, "Well, I can't believe she did that as a judge." You know,
Already?
yeah. Well, I mean,
Yeah.
you're bound to get that.
I am. And
I mean, I don't know. I mean, and I've never run for politics. I've never been a judge, but I just kind of see it as, in some situations, you're just in a lose-lose position. I mean, take for instance this week, with what happened with the ICE.
Mm-hmm.
You know, I mean, it is, if they don't shut down the courthouse in time, they're evil, because how can they make people come to court and forfeit bonds and everything else? If they're trying to work and see what they can do and tell people, be safe, we're not going to forfeit bonds, you know, everybody's then they're trying to, yeah, they'll blame them for whatever. I mean, whatever they try to do, whatever
Right.
the judges try to do, there's always going to be a cadre of critics who come out and say, well, that just wasn't the right thing to do. I just can't believe they didn't do that. Why can't we just all get on HISD schedule? Why can't they make it uniform?
right.
And I mean, I understand that argument, but you know, there has to be a process by which things change. There's no
Right.
uniformity.
And maybe that can be a change. Maybe there can be a streamline of the policies. I know that was a big topic of discussion this week about closing the courthouse. Do we make people come down? Roads might ice in the afternoon. Are they going to get home safely? I mean, there was a big discussion about it, and ultimately, the majority of courts closed. I think they still had jail docket because people are in custody and they still are needing representation. But instead of being in that cadre of critics, I want to be someone who can affect change.
Yeah.
I want to be a part of the group that sits down and says, okay, how can we make this better? Or what can we do to streamline the process?
Do you think you can, Lori? I've known you for years now. Fabulous defense attorney.
Thanks.
Do you think you can handle it? Do you think you can handle the politics part of it? You got thick enough skin for it?
The politics part has definitely been interesting. I knew that I was in for the unexpected. I knew there was no way I could anticipate this roller coaster ride. And it has truly been a roller coaster ride, but I do have thick skin. And for the most part, it's been a rewarding experience. I've met so many people, and I've met a lot of people who were saying, you know, yes, thank you for running. Thank you for, you're young and you're Latina and you speak Spanish and you bring a whole perspective that, you know, we haven't seen on the benches in Harris County, or we've seen too little of. So it's nice to hear that. It's words of encouragement for sure.
What do you bring to the table? What do you coming in? So you're young, Republican, strong person.
Yeah.
What do you bring to the table? I mean, is it that? What else? What distinguishes you from everyone else?
We're all individuals. I bring to the table conservative family values. I grew up strict Catholic, and I have 2 little girls, so I bring my conservative values from my upbringing to the table. I bring an energy that I think has been missing for a while in our misdemeanor courts. I'm ready to work hard, and I can assure lawyers that I'm going to follow the law. I'm going to give everyone a fair shake because I've been on our side. And our clients all have different stories, and whether they're guilty or not, we still need to provide a defense. We still need to listen to their stories, look at the evidence. And so now, instead of being a quarterback or I don't know, first baseman, I'm trying to use sports analogies here, I'm going to be a pretty good referee. I think I'm going to be able to call the balls and strikes. And if I don't know the answer, I'm not afraid to say, all right, let's take a break. let me go do my own research, look up the law, or send me your briefs. I'm happy to read them. I'll make a decision in a couple days or whatever's appropriate.
You brought up the fact that you're Catholic. Do you see that influencing you on the bench, or do you feel that? How do you feel that's going to impact you on the bench, or is it even going to be something that will impact you on the bench?
Well, I don't think I'm going to bring religion to the table. I'm going to follow the rule of law as written. And I reference my upbringing because I grew up in a conservative household where family is important. And being a judge on a bench, we hear from our defendants all the time, I need to support my family. I need to get back to work. Coming to court so often for all these resets is hard for me to do because I'm missing work or I need to be with family. And so having that perspective, I'm all for having longer reset periods for the cases that need it. I'm all for having a call docket so we can order the cases up for trial and not have people just come to court endlessly when they don't need to, so that they can work, so that they can take care of family, so that they can, live their lives and still participate and be, handle their case, but not miss so much work, not miss so much family time.
You've talked about resets and getting longer resets. How do you plan on doing that? Do you have a plan for that?
I do. So, for example, a DWI case. When there's blood involved, it traditionally takes, 90 to 120 days to get blood results back. Bail reform issues aside right now, usually those defendants are supervised while they're on bond. I don't see the need for them to come to court every 30 days unless they're accused of having a violation. If they're blowing positive into their interlock device and they're drinking alcohol, they need to come to court and we need to see what's up. Or if they're missing appointments, missing random urinalysis tests, they need to come to court. But otherwise, let them go and be supervised, blow into their machine, report like they're supposed to, follow their instructions, and then come to court when we know we're going to have their blood result back.
Right.
I think that just makes sense.
You talked about things of interlocks, blow schedules, or random urinalysis. What's your opinions on those? I mean, what's your stand? I know every case is different, but what's your feelings on those types of things? Are they good? Are they bad?
Well, I think that the bond conditions are for the safety of the community. I heard a statistic, and I know I don't have these numbers right, but the citizens of Harris County far outnumber the number of police patrolling the streets. So if someone gets pulled over for a DWI, it's pretty egregious driving, or it's an accident that's occurred. And to me, in a DWI case, for instance, those bond conditions are just guaranteeing the safety of the community, because we don't want that same person who may or may not have a drinking problem to be out on the road intoxicated again, because God forbid there be an accident, serious injuries occur, maybe death. We want to, and Houston is a town of drivers. We don't have the public transportation that other cities do. We're all driving, so we need to be sure for the protection of the community that those drivers are safe.
Do you feel that there could be other, or will you explore other means of supervision while people are on bond? For example, we hear some judges using the patch. We have some judges using the interlock. We have some judges using the scram device. Are you open to those types of things, or do you have limits?
I've heard the rumors about the unpredictability of the scram device. Right. So if elected, I want to research more about that to see, is it truly effective, or is it just a really expensive, unpredictable piece of machinery that's not a good gauge for whether someone's drinking or not. I've also heard of the patch, but all of these things are expensive, and that to me, I hear it all the time. Ms. Boteo, I can't afford to get a scram on my ankle. It's $400. I don't have $400, and I'm a court-appointed lawyer, so that truly means when they say they're indigent, if they can't afford a lawyer, they definitely can't afford a machine like that. And so I want to do more research on these things before I start signing orders, making people have these devices.
You talk about poor people not being able to afford things like interlock and the patches and the scram devices. What's your opinion on ordering poor people, or people who can't afford it, to have them? Is that something that's being discussed within the judiciary or within the campaign trails? As how are you going to get around that? Because these poor people, they can't afford the scram, they can't afford the interlock. Is there discussions about that, and what's your opinions on it?
I haven't had discussions like that with any members of the judiciary, and no one's really brought it up on the campaign trail, but it is an interesting area that we need to look more into.
You know, Judge, a fearless innovator and champion, I mean it, Judge Stanley. I had a client, she couldn't afford the interlock, so judge ordered her, said, fine, you can't afford the interlock, then guess what? Then you come downtown. It was still cumbersome, it was, but you come downtown, you take a drug test every week instead of the machine.
Yes.
And she did it. And ultimately, we ended up getting a good resolution to her case. Things like that. So do you believe that the judiciary should be using things like pretrial services, those resources, for people on bond and such?
Definitely. I think that's a big help because the judicial members can't do it themselves. I think pretrial services has really done a good job stepping up, especially after this bail reform new practice had to come into play. And so, I think it's good that these judges, that they have options. And I hope to say in the future that we have options. But ultimately, you know, it is case by case. I do even have clients who say, oh, I am driving, don't tell judge. And it's like, what am I going to do with you?
Don't tell me.
Don't tell me either. And it's hard. You have to say, you've got to get this machine. The machine's the cheapest device on the market, actually, if y'all weren't aware.
Right.
So
It's
it's
just put the machine in a
just
car.
put the machine in your car.
Put the machine in a car.
Yes.
Yeah. No.
Now, you do have an opponent in the primary.
Yes.
And Aaron Burdett, who we have invited on the show. He is not committed to coming on a date yet. Hopefully he will commit on a date to come on as well so we can get his views and hear his story as well. But he's a prosecutor. He's been a prosecutor, I think, his entire career, as far as I know. How about you? Where did you start out in the practice of law? Have you been a prosecutor? Have you done
I have
other
never
things?
been a prosecutor, ever. And that was a choice I made. I think in college I had so many jobs that my dad couldn't keep track. And he said, you know, Lori, you just need to work for yourself. You need to be your own boss, run your own business. That's where you're going to be successful. And he was spot on right. I graduated.
Somewhat overrated sometimes.
No, it's been a blast. It's been great to be solo practitioner. I started doing real estate transaction work right out of law school because
Fascinating.
no, it was not
Like doing title work and stuff?
writing loan documentation, some oil and gas, researching the chain of title. It was
Like a landman.
no, it was just
Even
like a
more-
little
even
bit of
worse than that.
everything.
Okay.
And the market started to tumble in 2007. So I was looking for other things to do. And a friend who's actually at the PD's office, Public Defender's office, invited me to some CLE for criminal cases. And I said, sure. And I really enjoyed learning about it. And then he said, you know, with this CLE, you could get on the list in Galveston. And I was like, really? Oh, okay. And I filled out the paperwork and I had a couple of cases and 2 weeks later, and it was just never looking back.
What thrills you of being a defense attorney? What is it? Is it the closing argument? Is it the opening? Is it a trial? Is it the motions? Is it impacting people? What does it for you as a defense lawyer?
As a defense lawyer, it's hearing people's stories and hearing. Everyone has a side to the story, and it's also looking at the evidence, making sure that the government did its job and didn't, you know, overstep their bounds or make any shortcuts. And then I had my first trial in 2012, actually 12-12-12, and it was a not guilty. And I just remember doing voir dire, talking to the jurors, having that conversation, that was just like, that was awesome. And so that's actually my favorite part of the trial is voir dire, talking to the jurors and getting feedback. And I'm still strategizing when I'm doing voir dire. And so that's exciting to me. And thinking on my feet, because we don't know what to expect in trial. I mean, we know what the evidence we think it'll show, but we don't know what a witness is going to say, or because often they won't talk to us before trial. So that's exciting, having to think on your toes, and you hear something bad and, oh, objection, you know, that's exciting to me.
Do you find that you mentioned you've only been a defense attorney.
Yes.
Do you find that there's a difference, and I'm not necessarily saying positive or negative in either way, but do you find that experience is different than coming to the bench as a prosecutor versus a defense lawyer?
Right, definitely, because I think where we hear prosecutors say they've handled thousands of cases, well, we see prosecutors every day in the courtroom grab a file, skim the offense report, make an offer, and pass it on. And they probably never see that file again. And I think to them that counts as handling the case. Whereas when I look up my stats, I think I've handled about 2,700 cases just in Harris County. And I do more than just skim and read the offer and talk to my client. I read the report. Often I negotiate with the prosecutor, advise my client, here are your options. And most often I have to look at the evidence, body cameras or videos or witness statements, and then people who want to fight their case, I've got to get it ready. So I think as a defense lawyer, we handle cases a lot more thoroughly than prosecutors do. And so I think that experience gives me the edge.
We got a caller on the line to ask you a question. Are you ready?
Sure.
All right, let's get him on here.
Really?
Hello, thanks for calling Reasonable Doubt. Hello?
Hello?
Yes.
Yeah,
Can y'all hear me?
we can hear you now.
So I wanted to kind of go back to something that y'all were talking about a minute ago about bond conditions, and I think Ms. Boteo said that they are to guarantee the safety of the community, and the examples were given about DWI cases giving people interlocks or scram devices and things like that. I have kind of two questions, and I want to maybe the first one's my main one. I have a client. I'm a defense attorney. I have a client who has two vehicles, and he has a device in each vehicle. The court only knows about one of the vehicles because when he went to get the one installed in his second vehicle, the interlock company told him that it's only $20 a month to have the device in there monitoring his alcohol and shutting off the car, locking him out if it detects alcohol at a certain level in his system.
Uh-oh.
The additional $50 that everybody ends up paying is a monitoring fee, supposedly, that if you wanted to install the device in your car and you are being monitored by a court, it's $75 a month. If you want to install the device in your car and you're not being monitored by a court, for the same device to do the same, to have to serve the same function, it's $20 a month.
Why would you
And I
do
think
that?
that's a pretty big difference. I haven't looked into whether or not that's true, but my client,
would you do that?
he's been paying this for years. He's paying about $95 a month for two devices, and he's told by Intoxilock that if the court has to monitor both devices, it'll go up to $160 a month. So given that that's what things are and that people are strapped and not able to pay for some of these devices, are there ways that the judiciary can save people money instead of these one-size-fits-all bond conditions? And then along those same lines, is it really true and fair to say that these kind of things guarantee the safety of the community? Because on one hand, you have somebody who has a device in their car. They cannot drive that car if they have alcohol in their system above a certain amount, a very low amount, not legally intoxicated, much lower than that. It locks the car out completely. But what safety is there in the community if someone who's only been charged with a DWI and has an interlock in their car, why can't they drink in their own home or in a drinking establishment? I'm not talking about public intoxication. I'm not talking about assaults that come from, I'm just talking about the person who wants to have one or two beers after work, but they're on bond for DWI. If they're not going to be driving and they can't drive the vehicle that they have if they drink a certain amount, drink at all, then what guarantee is there to the safety of the community? Or is this really more of just an easy way to revoke bonds if a judge wants to do that. And that's a lot, but I just wanted to kind of throw that out there and see what
That
you
is a
think
lot,
about that,
caller.
Mr. Taylor.
Thank you for.
Thank you.
Do you want to take question 1 or question 25? Which one do you want to
Well,
start with?
I think I do need to. If I don't think interlocks guarantee the safety of the community, I just think the condition is a helpful safeguard for the community. Because I don't know if you missed this part of the response I gave earlier, but the number of citizens in Harris County far outweigh the number of law enforcement. So if somebody is pulled over for DWI, it's pretty bad driving or there was an accident. And I think those drivers should be monitored just to make sure that they are not drinking and driving. Although having a drink and then getting behind the wheel is not illegal, if you're charged with DWI, I don't think it's because you had a drink. I think that's a very minority of cases. I think it's multiple drinks. But ultimately, it's to be a safety measure. And I don't know that everyone is on a blow schedule. A blow schedule is when people have to blow in between certain hours of the day, like from 6 to 8,
11, 1,
lunchtime.
6, right.
Right. So not everyone's on a blow schedule. So it is possible for people who had an interlock to say drink at home, as long as they're not trying to, go get some late night takeout after they're drinking and blowing into their machine. That shouldn't be a problem. But it's a problem when they're going to bars, happy hour, having way too many margaritas, and then getting behind the wheel.
So, what's your stance on? It was mouthwash, Judge. It was mouth. That's a joke.
We hear it all the time.
It was
I
a
know.
joke. You're not supposed to do those things. Anyways, so let's talk about that was a joke. Poorly executed joke,
Yes,
but
a
it
little.
was a joke. So so let's talk about bonds. You've referenced the bail reform lawsuit. Earlier this week, there was a news article that talked about the probable cause judges getting sanctioned or reprimanded.
Yeah. For not granting PR bonds.
For not granting PR bonds. I will say today, Judge Harris in the jail docket gave a number of PR bonds to my clients, which was great, because I thought she didn't really like me much, but it turns out that she was just following the law and doing what she needed to do. So what is your opinions or feelings on the bail system as it is now post lawsuit? So PR bonds, unsecured bonds, PR bond, unsecured bond.
Well, it's an injunction. It's at the injunction stage right now, and I think they're waiting on a decision from the Fifth Circuit about whether it needs to stay in place or if we revert back. But I don't think we're ever going to revert back, because it was brought to everyone's attention, not just defense lawyers, but prosecutors, judiciary, public, that people charged with crimes like driving while license invalid, those people were being held in jail with like $5,000 bonds or $3,000 bonds. And the only reason they don't have the license is more than likely due to not paying money to DPS. And so that was, the term debtor's prison. And I think people charged with those types of crimes should definitely get PR bonds so that they can get back to work, get on a plan to start paying that money. So I think PR bonds for those types of folks are great. It's the unsecured bonds that I have an issue with, because I've represented multiple people since this new change that have some mental health issues, and they'll get like a criminal trespass, they go in jail, they get out, they get another criminal trespass, and it's just like a revolving cycle, and it's not good. Because by the time someone says, whoa, wait, that person's got 5 cases, and then somebody's finally saying, wait, what's going on? And so that's a problem that needs to be solved. And the unsecured bonds, we don't have any way to verify where these people are going, how we get a hold of them. So I like the verification process with PR bonds. I like that pretrial services makes the call and says, okay, he lives here, this is a number, and we can reach you as a backup. Great, thank you. Okay, send him on away. That's a good solution to me.
As an anecdote to piggyback, I just recently had a trespass, PR bond, trespass, unsecured bond, trespass, unsecured bond. filed a competency evaluation, unsecured bond, so she didn't. Right. Came back, unsecured bond, filed another competency, unsecured bond, got a, right. And so finally, I don't know which judge it was, but finally a judge said, okay, no more, no más. It's no more, that's no more in Spanish, no más.
Thank you.
Right. Finally, and she came back incompetent. And so that was a big deal for me because this individual kept getting out. I kept filing for competency evaluations, and she kept getting out before they could do the competency evaluation, which was a big deal for me. And I said, you know what, there are problems
Right.
with that. As a general principle, what's your opinion on unsecured bonds? I know you said, okay, so on trespasses and driving while license invalids, maybe not. But as a general principle, what are your feelings as far as unsecured bonds?
I don't like that the sheriff has become a bondsman. I don't
Fair.
really like that people are just getting arrested, charged, and then walking out. I like the PR bond system because pretrial services has to verify the information provided.
Right.
And once it's verified, they're out. And the defendant can get back to work, get back to family. And I think that is a much better system to follow than the unsecured bond system. And you've also got people getting unsecured bonds charged with misdemeanor assault, which is, you know, slap or punch or push or fight, whatever you want to call it, it's still an assault. And that's a crime of violence. And I don't think people charged with assault should get an unsecured bond. I think they definitely we need to verify, okay, if it was a domestic violence issue, does this defendant have somewhere else to go besides the home? Just to have a cooling off period. Right. I'm not even getting into emergency orders for protection, but just to simmer down, cool off.
You mentioned magistrate's orders for emergency protection. What are your feelings on those, or what's your opinions on those?
I don't like to see them put in place before the complainant is contacted.
Fair.
Because it's so difficult for the complainant when I represent people and the complainant says, no, I don't want this in place. I need my husband in my home, or I need my wife, to then approach a judge and say, you know, Judge, we really want this removed. She's here, and it's just a difficult situation. So I would rather the complainant be reached first by the prosecutor. And then if the complainant wants a protective order, move for it at that point, but not prematurely.
Now, the magistrate's order for emergency protections are in place upon motion of the state. So how do you envision, every case is different, but how do you envision yourself handling those? Is it like, do you say, oh, well, let's approach the judge and talk to the judge about this MOEP that they're trying to enter first? Or how do you envision that happening?
Well, I definitely, if it's not done in front of the magistrates, like most of them are now, I believe,
Right.
I'm definitely willing to listen to the state's motion to have one put on, or to defense counsel if the complainant wants it removed and the complainant is there to give testimony before the court. I'm definitely willing to listen.
Do you think that's a difference? I think it may be. As a defense attorney, we like to say, wait, the guy's presumed innocent. But as a prosecutor, you put your prosecutor hat on, you say, no, let's do the MOEP first. Do you think that's a difference between maybe what you bring to the table and your opponent brings to the table?
Oh, for sure.
Is that something that, like,
For sure.
that's wild. It's a big deal. You guys should go out and vote. Like, I mean, whoever it is, like, that's a big deal. That's a big deal.
It's the classic showdown. You know?
It is a classic showdown.
Defense lawyer versus prosecutor.
Let's talk about dockets. So, how are you going to run your docket? Is it 832, state moves for bond forfeiture granted? Or is it, let's talk about your dockets. As a judge, you have to balance the interests of the community as well as judicial efficiency with your dockets.
Yes.
So, do you have a plan? Have you thought about how you would run a docket?
Well, right now, they're running because we're displaced. Once the Criminal Justice Center is back open, I'm really curious to see, are the misdemeanor courts going to be, the first few floors? Are we going to have escalators where people can just ride the escalator up instead of having all those elevator issues? Or does the discussion about having an afternoon docket need to be had? I'm definitely willing and open to ideas.
I swear to you, if you start talking about Saturday dockets,
Oh, no. No, no, no.
Well, but why? But why can't you? I mean, we have this argument every time. Why can't you just say, you know, look, initial appearance, motions hearing, trial date, and if you, you know, let me know if you're going to plea by this date, and we'll get a plea hearing.
Right.
And then if you run a docket, you know, you have jury selection on
Tuesdays.
on Fridays or Mondays or whatever.
Right.
Trial date's this, and then you know Fridays are open or whatever. Fridays are our plea docket, or
Right.
Friday mornings our plea docket. Friday afternoons our motion dockets, or whatever. I mean, you know that's what I don't understand, because each judge can set their schedule and really make things efficient. And I think now, especially where you're sharing courtrooms, we have limited space. Now is a great time to experiment.
Yeah.
And see what can make things run more efficiently. You know, and getting back to the whole conditions and everything. I mean, I hear what you're saying about safety and trying to figure out, you know, if people who can't afford it can pay for it, but in trying to figure out alternatives. But at the same token, I think there's a large segment of the population who say, you know, look, yeah, I'm sorry that these people can't pay for it, but you know, they figured out how to get themselves into this mess.
You shouldn't have been driving.
They figured out how to get themselves into this mess. We're providing them a lawyer. The least they can do is pay for whatever conditions the court sees fit to monitor them on. Because let's face it, let's be honest here, all right, defense bar, not everybody that is charged is completely 100% innocent, okay? I mean, there are some of those that do happen where people get filed on, and you know, it's the charge isn't right, and you defend it. And yes, I understand that, but by and large, you have a lot of people who are, you know, they're recidivists in the court system. They're coming back through. They're not just one-time DWI people. They're 2 times and 3 times and 4 times. I mean, how many times do you see on the news people getting charged with their 6th DWI?
Getting life sentences.
Correct. So,
Yeah.
you know, I mean, I hear you about the argument about these people. We need to figure out a way for them to be able to, you know, pay for more reasonable things. But in a lot of situations, these people, you know, figured out a way to get themselves into that position in the first place. And so I don't think it's unreasonable to try and meet in the middle somewhere. Yes, I mean, okay, maybe we can find something that's maybe more economical and affordable, but you know, I don't think you can just let them walk out the door. Do you?
No. I don't think so.
Oh,
I think
wow.
for the most part, no, I don't think so. I want to do that. But God, man, it feels so good walking guilty people out the door, though.
Yeah.
It feels so good, man. You're like, boom, you did it, and you out.
And it happens, and I'm with you, Lori. I think the PR bond is a better situation than just going with a complete unsecured bond.
Right.
You know, because I do think, you know, at the end of the day, what is the purpose of bond? It's to ensure the defendant's appearance in court. That's the ultimate goal, right? To
Right.
make sure they come back.
Right.
And if they don't have at least a little skin in the game, what's going to make them come back to court?
Right.
Going back to
They don't have to be punitive.
no,
Right?
that's correct.
I, mean,
Yeah,
I think that's the issue,
Interesting.
is that for so long these bonds have been punitive.
right.
Okay, and that they're such that they cannot get out at all, and that's wrong. I mean, people should not be held on misdemeanor offenses where they can't defend themselves. Okay, but you know, I mean, if you don't have any skin in the game and there's no risk, why would you show up? Because I mean, the overriding purpose is to ensure their appearance in court.
We have going back to the unsecured out. I count on them. Some of them not like I'm like, oh, he's not showing up today. It would be just fine. But he's going to pop up on my docket in about a week, and I already know this.
Yeah.
Going back to dockets, so do you have, I mean, what's your opinion on docket control orders, scheduling orders? Are you not about that, or is it going to be every day, 30-day reset? I mean, you talked about
I want longer resets.
longer resets
for
and
the
such.
cases that call for it.
What about defendant's
Why can't we
appearances?
just do away with resets? Why can't we do away with the whole reset system and just go to a docket control order like every normal court in America does?
Because how often does the docket control order actually get followed without a continuance?
That's what the judge is for. You're supposed to be the referee.
Well, and plus,
What does the referee do? The referee ensures order, right? The
Right.
referee ensures that, that the batter doesn't go take the bat and whack the pitcher's head off.
right.
That's what it's supposed to do. So if you have a docket control order, you say, all right, you bring a motion for continuance, and if you have cause, okay, defense, what are you asking for? You're asking for 180 days. State, are you in agreement? Well, no, we don't agree. We're opposed.
Right.
Okay. Defense, I'm giving you 60 days. I'm not giving you the full 180.
Right.
Just because the defense asks for it doesn't mean they get. I mean, how often have we shut down?
A lot.
But I mean,
But the sheer volume of misdemeanors, I
Right.
think, would prevent docket control orders from feasibly working as much as we would want them to.
why?
Because so many misdemeanors are
should-
filed every day.
But shouldn't a continuance be for good cause?
Yes.
Okay.
But sometimes the government takes a lot of time to get their evidence. DWI cases is just one example, but what happens when that blood test comes back and it's 0 for alcohol?
Yeah.
Then they send it to Austin for drugs. How long does that take?
Another
That-
120?
But that's not every case though.
That's true.
Okay. I mean, and with this new e-file system, if it works like the way we say it's supposed to work, you should be able to just pull the continuance up on your screen, enter
Right.
the order, boom, sign it, put the date in, and go. I mean,
Right.
this really shouldn't be a ministerial headache for people.
And I don't think it should be. I agree with that. So the ritual of every 30 days a defendant needs to come to court. I think that's an archaic practice, and I'm open to longer resets. But I also think implementing a call docket, which is something an idea I've had for a long time.
What is that?
A call docket, so say you're set for trial on Tuesday. The Thursday before that Tuesday, just the lawyers need to come in, not the defendant. Lawyers come in and say, Judge, we're ready, or no, state's missing this evidence, or defense says, no, I have a conflict, I can't try the case. Okay, fine. That way, whenever Tuesday comes, the jury panel can be pulled and know which case is going to trial. There's
Right.
not that game of, ooh, I'm number 6.
Right.
But hey, are you 5? Are you going? Hey, are you 4? Oh, you're pleading? Okay, ooh.
Right.
It eliminates that. So the lawyers know they're going to trial. The state knows they're going to trial on this case on that Tuesday. Jury panel's pulled, sat, voir dire.
You know who
That's
does that? District Court Judge Velasquez. And I have found it to be amazing.
Yes.
I get to go in there to court, no defendant, talk to the DAs, have a little conference with the judge, and your real setting is next week. But maybe not. If we're talking about it all right now, I get to reset whenever I need to do, or yes, Judge, next Tuesday he's coming in, we're going to do the plea.
Yep.
Or yes, Judge, next Tuesday we're coming in, we're seating the jury.
Right.
I found that to be great. And do you feel you can do that in the misdemeanor court?
I really do think we can. I think we can. Because there's so many cases set for trial on trial day. I don't know about y'all, but I spend my whole weekend prepping, getting everything ready, organizing my binder, just, getting ready for the trial. So that when it comes, I show up and I'm ready. So if everything falls apart, which has happened to me, I'm ready to go.
Right.
But to avoid the drama of that morning, and also to avoid pulling a jury panel and having them sit in the hallway. How many times have you seen that? 30 people just standing there and just waiting. And it's painful to see them. And I actually did jury service this time last year, and I had broken my foot. And so I was on a knee scooter. I don't know if y'all, with the
Wheeling
bell,
around, yeah.
I was wheeling around, and I was pulled for a jury panel. And I waited for so long, and I had just broken my foot the weekend before, and I was supposed to be elevating it, and it was I was literally in pain, just standing there and trying to elevate my foot and uncomfortable. And so I thought, gosh, there's a better way to do this.
As Charles Barkley would say, that's terrible. Terrible. Okay, so.
Oh,
we got a
phone call.
We got a phone call. Oh. Let's, what?
No, it's a phone. I'm excited.
You got phone call number 2 here. Hello, thanks for calling Reasonable Doubt. Hello.
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 Hola.
Nope.
Nope.
Nobody there.
Oh.
Hello.
Hi.
Hi, can you hear me?
We can now.
Okay, thank you for taking my call. I had a few comments and a question about the unsecured bond comments that you guys made earlier, and for the candidate who mentioned that she doesn't like them. I'm a defense lawyer, and prior to the federal injunction, I had several clients who were admittedly homeless and whom I made constitutional arguments for to the judge to have them released on PR bonds. And of course, due to pretrial services being unable to verify their residence or any contact information, they were not granted PR bonds. And I found that to be troublesome for a couple of reasons, but I think the most important one was that the judge would tell me that he didn't have a problem with them getting a PR bond as long as it was okay with pretrial services. And all of those homeless clients who were later released because that federal injunction happened to come out at that time ended up coming to court. And it was a big surprise to me, and I'm sure it was a big surprise to everyone. So the comment I have is, how can you tell that someone's not going to come to court because they happen to be homeless? And how can you keep them in jail or not give them a PR bond or an unsecured bond because you think that they might act a certain way because of their financial or socioeconomic situation? And what steps would you recommend in lieu of giving them unsecured bonds, since the sheriff is having to act as a bondsman now? And the other comment I had slash question is the fees for pretrial services or bond conditions or even pretrial intervention programs are oftentimes cumbersome. And when you've got clients who are homeless or don't have family support or who are 17 years old dealing with other issues or 18 years old, obviously they're having to pay these cumbersome fees is not helping reduce recidivism, or it would be reduced now. So what alternatives would you recommend in lieu of some of these conditions? And isn't getting a warrant issued for you if you fail to come to court enough government intervention to secure your presence? And I'll take your comments off air. Thank you.
Thanks. We need to teach these defense lawyers to confine their questions to a couple.
That's what I'm talking about, Lori. You're about to make some tough decisions.
Yeah.
You know what? These people are indigent. They can't afford those bond conditions. And just because someone's accused, as you know, don't mean they're guilty.
Right.
How are you going to balance that?
So, yeah, that's tough.
That's tough.
That was a really good. I have also represented homeless people. I understand it's hard. Whenever I've had the chance, I've referred some of my clients to social workers who work for the Public Defender's Office. Did you know our Public Defender's Office had social workers? They have social workers to help guide them, because some people don't even have an ID.
Right.
So where do they go to get that? Because they need certain information. And it's nice to be able to say, okay, I've talked to the social worker, here are the resources that I can get for you. I don't think that just because someone is homeless, that person should have to remain in jail. It's 7:45, dude.
Oh.
And
You're an hour off.
That was a secret.
oh, my bad. So I just think it's got to be looked at case by case. If a defense lawyer brings a homeless person in front of me and we need to talk about whether it's at a jail docket or a bond docket, to say these bond conditions are too cumbersome, can't afford them, what alternatives can we look at? I will definitely be open to exploring alternatives.
Well, but I think that's the point, is that each case needs to be dealt with and looked at and dealt with on an individual level. And we shouldn't be trying to shoehorn everybody into one set of
Right.
facts or circumstances or conditions. It's not a one-size-fits-all deal. It shouldn't be. And, you know, and we can always sit here and we can always talk about, well, the homeless this and the homeless that. The reality is, if you walk up and down the halls of the criminal courthouse every day, it is not filled with homeless people who are coming to docket, okay? It's just not. That's, you know, it's not there. Now, is that because they're in custody? Is that because they've been, what's the real story? But when you look out in the audience, okay, yes, you have a mix of people who are sitting there in suits who have clearly, you know, come from means, who are charged with DWI because they went out to some high-end club and got their stupid bottle service and got drunked up and decided to drive, you know, their car home.
Or possession.
Or possession of cocaine or possession of marijuana or whatever. You've got that mixed in with the guy who is, you know, working down at the plant. I mean, you've got every
types.
different size.
All walks of
okay?
life. Yep.
This isn't this. You can't just put everybody into the same system and make it work for everyone.
Yeah.
So I mean, I agree that we've got to find a solution for everybody, but we can't just. In my opinion, we always just want to go to the very worst case scenario and say, well, the whole system has to change because this person who's the very worst case scenario. And it's not like that. We're leaving out all the people in the middle.
Right.
You know, and that is what's happening across the board in our country today. We're worrying about the people at the top, and we're worrying about the people at the bottom, and everybody in the middle
Where's the middle?
being
Hey,
crapped on.
what about me?
Yeah.
What about
So,
me?
you know, I mean, each case needs to be looked at on an individual level.
For sure.
And, you know, the question is functionally, how do we make that work? I mean, if our system is so overloaded that we can't have a docket control order then how do we bring individual bond questions before a judge?
Well,
Well,
we could certainly, I think with this,
Seems to me if you had a docket controller, you might have more time.
you really
To
want a
address-
docket controller.
okay.
Well, it seems like you might be able to free up time on a Monday
Yeah.
if you're not doing stuff to say, hey,
Well, here's,
let's have bond hearings on Monday. Bring your
Right.
bond appeals to me, everybody. I'm just
that's a good idea.
thinking out loud
No,
here.
no, you can't. You know why? Because then you're gonna have to work past 1 o'clock.
That's okay.
I said it.
Ooh,
I said it.
burn.
I said it.
It's not a burn for me. I work past 1 o'clock.
Oh yeah, we do.
Yeah, but it's something I definitely want to look at. Got to look at the options. And I think a big change, we're doing the e-filing, but so is the state. The state is now, instead of printing out their files, everything is going to be online
And all
in
the-
their portal. So we don't necessarily need to have a specific setting so that they can bring their file.
Right.
We can come and approach as long as the defendant's present, because I think the defendant always needs to be there when
Why?
because we're talking about that person's case.
Okay.
Fair enough.
It's not
Okay.
it's not the defense lawyer's case. I can make all the arguments I want. I go home. I don't have to blow into an interlock.
So
Fair
here's
enough.
the other
That's-
question. You say it's at the DA's portal. I only see one portal in the courtroom.
On your iPad?
No, I only see the DAs only have one computer sitting there.
Oh, they've been bringing laptops.
They got and now they got kiosks.
I haven't seen the kiosks,
they're
but
in-
I've seen
they're
a
in the
lot more
court. Well,
laptops
they're yeah.
in some courts.
They're laptops. I say kiosk, but they're
Oh.
laptops now.
Oh.
And they hook in.
Yeah,
I
dude.
think
They
kiosk.
link
I
up.
think like what you have in the mall where you buy your.
Everything electronic you can do.
Every-
There's an app for it now.
So they don't have to have a setting on a docket to approach. Because that aggravates me. Like, Judge, we don't have our file. Well, come on. Can't we still talk about it? Can't you? And now that we're not in the criminal justice system and the file is blocks away, they can't go get it. But now things are going to be accessible online. Reports, we can have conversations without necessarily having it on a docket.
Okay, Laura. What's the role of the judge, in pretrial interventions? What's the role? What are you stepping in? You're not stepping in? Is it your place to say? What's your opinion on that?
So on my campaign data, and please go to www.loriboteo.com, I'm going to let parties make pretrial agreements. I don't want to be one who interferes, because I've been in that situation where I've negotiated something for my client wants it, the state wants it, and then we have to go to the judge, and then we start being asked, well, what are the facts of the case? And the agreement's done, Judge. Can't we just get the year-long reset? I want to say I'm not going to have a problem with that. I can see where some judges do, but I want to let the parties make agreements.
You know, you're exactly right. State wants it. Defense wants it. It's my opinion. I agree with your opinion. But we see it.
And not all judges do it.
Not all judges do that.
It's not a consistent thing that all judges do, but
Right.
there are some who are known for saying, no, can't do it. And that the judge hasn't been a party to the negotiations that have gone on, to the emails and here are the circumstances, the behind the scenes facts, aside from the facts of the case. And so I don't want to interfere. If the parties are ready to make an agreement,
Well, then let me ask you this. That individual on the pretrial intervention is going to have to be supervised, let's say via an interlock or via your analysis or via a patch,
and we'll still be on bond.
and still be on bond, and they're going to be using resources from the Harris County taxpayers,
Probation department
right?
or community supervision department.
Right. You don't think that the judge should have a say in that kind of stuff?
If there's a bond violation, because the person will still be on bond
Right.
during the pretrial agreement. So if there's a bond violation, then yes, there will have to be a court date to have a conversation about what's going on. The DA's office is always open to changing their policy. They can make an agreement, dismiss the case, and if there's a violation of the agreement, DA can refile.
Like the rest of the planet.
That hasn't happened, so we have it currently the way it is. Maybe there'll be a change. I don't know. A lot can happen in a few months. We'll see.
Again, you can't win, though.
But I can win if you vote for
I'm
me.
not talking about that. But I mean, you're gonna. What I mean is, if you win it, if you win the bench, you're gonna have people who are okay with your policies of doing certain things, and I know there's a split, and I know we only have a minute left, but I mean I know there's a split in the Republican Party right now, because we saw in the last election, we saw a lot of Republicans who voted for Kim Ogg as opposed to Devin Anderson, and there's I would say a pretty even split in the Republican Party right now of those who want serious criminal justice reform versus those who want to keep the system status quo. And so, I mean, what do you think is going to happen locally with those? Because I mean, it seems like the races where you have two candidates, that's where the divide is.
Yeah.
The ones who want criminal justice reform from the Republicans, and the ones who want to keep it the status quo.
I'm encouraging everyone who has questions or feedback or comments to talk to me. I'm trying to meet as many voters as I can because I'm truly running a grassroots style campaign with support of family and friends and colleagues. So I'm just trying to get the word out about what I want to do, that I have ideas, that I have the energy to bring it all to the table. And I'm hoping to earn the vote, and so that I win the primary and face the Democrat in the general.
Hashtag earn it.
That's all the time we got.
Nice.
We got to wrap this sucker up. So, huh?
Yeah, that was fun. Time
that's-
flies on this show.
I know.
Wow.
We appreciate you coming on. That's all the time we have for this week, ladies and gentlemen. For Lori Bateo, Julio Vela, I'm Jimmy Ardwan. We will see you next week. We actually won last night, didn't we?
What?
Pardon?
The Horns.
Yeah.
Yeah,
Oh, I
we
don't
did.
know.
Basketball.
LoriBoteo.com.
There you go.
Thank you.
That's all we got, ladies and gentlemen. Good night.
Good night. Time flies, y'all.